Okay, we are live and we are going to continue our discussion on S47. As you recall, yesterday we had quite a discussion about the issue and some different proposals, and we were trying to work out something that we could address now and work on something in the future. So I don't know if progress has been made or not, but Anthea, why don't we turn it over to you and see what's happened? Thank you.
Okay, so I will say a little spiel, and then maybe Senator Perslick wants to say something as well, since I've worked closely with him on this language. But posted to the committee page under today's date, under my name, is a strike all amendment for S47 draft 1.3, which I was planning on walking through. You also have up there posted under Claire's name Veda's response to draft 1.3. And while I certainly can incorporate those changes and get that to the committee if they want to include them, it's less than basically 24 hours since we started working.
Right. No. Listen, we don't have to complete it. We just continue the discussion. If we're not prepared for prime time, that's fine. Yeah.
We're definitely prepared for prime time with a version, and I think you're going to hear comments as to why it should be tinkered with a bit before it is fully.
All right. Okay.
So I can do my walkthrough, or Senator
Sure.
Perslick, I don't know if you had anything you wanted to add.
No, I think the walkthrough is good, but it seems good. I think we'll hear from Claire and the dealers today for sure, but it seems like we made progress. So at least I have hope for a bill, I think.
Okay, go right ahead, Anthea, please.
Okay, so this is version 1.3. It's the first version you're seeing. It's crafted as a strike all amendment, so it would be replacing all that is currently in S47. So the direction that I was given was to incorporate Veda's proposals from number 1 and number 7, and also address the underlying issue in S47, which was the direct sale manufacturers having a warranty or service center, and then also to include something that was maybe a bit stronger than a report in terms of the committee's intent to look at the other franchise issues for proposals 2 through 6 next year. And maybe even it's something that the House would change around and actually incorporate some of them. So all the language that you're seeing that's changes to statute is going to be addressing the 2 proposals, 1 and 7. Those are the ones that dealt with the competition between dealers and manufacturers, and then the piece on the direct sale manufacturers. So section 1 is amending 9 VSA section 4085. That's the definition section for the dealer franchise law. In subdivision 13, changing the new motor vehicle dealer definition. It's rearranging what's there a little bit, but adding additional acts that dealers are allowed to do. And then later on, we're going to see language that actually prohibits manufacturers from doing them, except for the new definition we're creating for these certain direct sale manufacturers. So if this amendment is incorporated, a new motor vehicle dealer would be any person who holds or held at the time a cause of action under this chapter, and that's the chapter that deals with the dealer franchise law, a valid sales and service agreement, franchise, or contract granted by the manufacturer or distributor for the retail sale of that manufacturer's or distributor's new motor vehicles, and then the entity is engaged in any of the following with respect to new motor vehicles or the parts and accessories for those new motor vehicles. The parts and accessories is an addition. So it's not obvious there since we're adding a lot of language. Everything except for the parts and accessories, that is existing law, just moving it around a bit. The parts and accessories is an expansion. So those behaviors that they would be engaging in are selling, and then in addition from Veda's recommendation is expanding it to or leasing, offering to sell, and then the addition from Veda is or lease, soliciting or advertising the sale, and the addition from Veda is or lease. And then the new language from Veda is offering through a subscription or like agreement those new motor vehicles or the parts and accessories. So from what are the substantive changes here? It's adding or lease throughout, extending it to the parts and accessories. And again, it's parts and accessories for those new motor vehicles if you have one of these franchise agreements. So it wouldn't be affecting like AutoZone from selling parts for vehicles, and then expanding it to also be offering through a subscription or like agreement. And I'm sure you can hear from some of the dealers what sorts of subscriptions or like agreements, what that really means in practice, and it is not something that I necessarily know. Would you like me to pause there or keep going to section 2?
Well, any questions from the committee at this point? Okay, go right ahead. Thank you. Go ahead.
Okay, so section 2, this is all new language. It's adding to that same definition section for the same chapter of law, a definition for a non-franchised zero emissions vehicle manufacturer. And this is all, and you'll see it on line 15, included with an and. So in order to be a non-franchised zero emissions vehicle manufacturer, which is what the exemption for the warranty service center and the prohibition on manufacturer behaviors will apply to, the direct sale manufacturer here, a non-franchised zero emissions vehicle manufacturer, needs to meet everything A through E. So they need to only manufacture zero emission vehicles, which would include plug-in electric vehicles as they're defined in Subdivision 8.5. So that would be under our definitions, plug-in hybrid electric vehicles and battery electric vehicles. They need to only sell or lease directly to consumers new or used ZEVs that it manufactures, or vehicles that have been traded in conjunction with a ZEV sale. So someone's buying a new zero emissions vehicle from this non-franchised zero emissions vehicle manufacturer. That manufacturer could then sell that other vehicle that was part of the trade-in. So it wouldn't be a prohibition from falling under this definition. The manufacturer needs to not currently sell or lease and has never sold or leased motor vehicles in Vermont through a franchisee. So that would be a dealer that has a relationship with a manufacturer under a franchise agreement. It has not sold or transferred a controlling interest in such non-franchise zero emission vehicle manufacturer to a franchisor, subsidiary, or other entity controlled by a franchisor. So the manufacturer cannot have its entity controlled by a franchisor or subsidiary, et cetera, of a franchisor. So that's a manufacturer. And it needs to be a registered dealer pursuant to 23 VSA Chapter 7, Subchapter 4. And that's the language that deals with sort of that in-person presence, the criminal background check that the DMV does, the needing to have your facility be open a certain number of days, the size requirements. So to be a non-franchise ZEV manufacturer, you're going to need to only make ZEVs. You're going to need to only sell ZEVs or your ZEVs or a vehicle that is a trade-in in conjunction with the sale of one of your own ZEVs. You cannot have ever had a relationship as a franchisee. You cannot have a controlling interest in your entity, be covered by a franchisor, and you need to be a registered dealer. So it's a multi-part definition that will probably, at this point, not cover a lot of entities. I will pause briefly, see if there are questions.
Questions, comments? Okay, go right ahead.
Okay. So now we're getting to the language that was in S47 as it was introduced. This is in 4086 subsection I. This is what currently exists that is prohibiting a manufacturer, which would cover under the existing law, an entity that was one of these non-franchise ZEV manufacturers, prohibiting them from having a warranty or service facility in Vermont. There currently are 2 exemptions, neither of which would apply to those non-franchise ZEV manufacturers. And that's for an existing manufacturer to operate a warranty service center on an emergency or interim basis. Existing law, line 1 on page 3. Lines 2 to 4, if no qualified applicant has applied for appointment as a dealer. in a market previously served by an area. And then Subdivision 3, this is the new language that would allow that just defined non-franchise ZEV manufacturer to have a warranty service facility. So it's saying that an additional exemption is if the manufacturer is a non-franchise zero emissions vehicle manufacturer that directly owns, operates, and controls the warranty or service facility. So this is what would then allow those non-franchised ZEV manufacturers to have a warranty or service facility in the state of Vermont. Section 4 is the language that would expand what it is that a manufacturer cannot do under existing law. It is expanding or eliminating the fact that the competition needs to be in the relevant market area, which is defined. And that's on line 15, striking that out. And then it's actually defining, for purposes of subdivision 8, what it is that competing means. And those are listed out in 4 subdivisions, little I through little 4. And those are the exact same things that exist up in that definition that we modified slightly for what it means to be a new motor vehicle dealer. So it's now saying that a manufacturer cannot do those things. So it would be selling or leasing, offering to sell or lease, soliciting or advertising the sale or lease, or offering through a subscription or like agreement. That would apply to the new motor vehicles and the parts and accessories for the new motor vehicles. And it is carving out from that prohibition any manufacturer that is not a non-franchise zero emission vehicle manufacturer. So in addition to that non-franchised ZEV manufacturer being able to have a warranty or service center, they would also be able to engage in these behaviors in Vermont, basically selling vehicles that are theirs without being in violation of this prohibition on a manufacturer engaging in these activities that are basically being reserved to dealers. Section 5 is the sort of report with a little more section. It's saying that it is the intent of the General Assembly to amend the Motor Vehicle Manufacturers, Distributors, and Dealers Franchising Practices Act, that's 9 VSA Chapter 108, during the 2021 adjourned session. It's saying that the amendments may address, but it's not requiring that it does, but it may address facility requirements, warranty and pre-delivery obligations, potentially unreasonable standards and franchise agreements, and the protection of consumer data. This covers generally, and certainly not in the detail that Claire went through yesterday, what it is that VEDA has brought up as where they think there are deficiencies in Vermont's current law. It's directing in subsection B that any persons that are interested in proposing an amendment to Chapter 108 needs to provide that to the Department of Vehicles not later than November 1, 2021. I simply picked them sort of as a clearinghouse for these proposals, and saying that persons may also file proposals on the establishment of a direct shipper license. That was VEDA's proposal that they said was not modeled off of what was happening in another state, but thought it would be something that would be beneficial to Vermont and Vermonters. Those proposals also need to go to the DMV by November 1 of 2021. It's saying to the extent practical, entities should cooperate and file joint proposals. Maybe you'll get the dealers and the manufacturers that will file one perfectly vetted proposal that everyone loves, and it'll be a joint filing. And then in subsection C, you're directing the Department of Motor Vehicles to file a written report with all of those proposals that it receives, and if it so chooses, its own proposal on the creation and implementation of a direct shipper license with the House and Senate Committees on Transportation and the Commerce Committees in both bodies, not later than December 1 of 2021. Everything takes effect on passage, and then simply to address the fact that the S47 title was more narrow than this bill would now be, changing the title of the act to an act relating to motor vehicle manufacturers, dealers, and warranty or service facilities.
Senator Kurt Berkeley.
Yes, thank you. Anthea, that section B, or no, I guess it's C, the report, shall file a written report. It contains, the way I read it, it looks like it's only referring to the direct shipper's license, but I assume we wanted to refer to all the proposals they received plus anything they received, or if they had their own on the direct shipper.
Yeah, so it says that the Department of Motor Vehicles shall file a written report containing any proposals it receives and its own proposal if it so chooses on the creation of. We could put in there any proposals it receives under subsections A and B of this section if you wanted to be very clear that the proposals are the ones that it has kind of collected from these entities that are interested in modifications to Chapter 108.
Yeah, I think any proposals it receives in its own proposal of A and B, and then also about the direct shipper. Because I think it could be read that it's all just about the direct shipper since it's one sentence.
I think we can definitely put some clarifying language in there.
Right.
Senator Kitchell, do you have a question? No.
Yeah, I thought it was good to, I obviously didn't like the word study because I do think a statement of intent carries a very different significance than, so I thought coming up with that way of approaching the work that needs to be done was helpful, maybe because we use the statement of intent a lot with our budget work.
Okay. Anthea, are you finished now or up to date or open for questions or?
I have nothing else on my walkthrough.
Okay.
But I'm
We have Senator Ingalls.
It sounds like we might be having the auto dealers come in, but
Yeah,
I just have a
they're
question.
waiting and the next I'll ask to speak.
I have a question for Senator Perchlik. Is this agreements that the out-of-state companies who want to put service centers here in Vermont, is this something that they would agree to?
I did send it over to them last night, and I got an email back from them saying, I think they also sent an email to Anthea. Yes, I think the short answer is they did support it. They had a question about a couple of the words, but I think we clarified that. So I think yes, we're all fine on that front.
Okay, I'd like to ask Bob Cody is with us this morning, I believe, and Mitchell J. They were with us earlier in the week, and to offer their comments at this time. Whoever wants to go first, go right ahead.
Well, if it's okay, Senator,
I'm
this
sorry.
is Claire Buckley.
Yeah,
I would like to just jump in, but Bob and,
Yep.
and
No,
Mitchell.
I'm sorry. I missed you. I'm
Yep.
sorry.
No, that's okay. I did respond. I received this proposal last night at around 8 o'clock from Anthea, and then was able to convene a group early this morning, and we reviewed it. And I sent comments, which I guess are on your webpage, to provisions. And I don't have I don't know if we want to share the screen or if you just want me to describe what they are. We so much appreciated the draft from Senator Perchlik and Anthea. And we do think that it takes us, based on your conversation the other day, it takes us very close, but there are two changes that we are asking. Well, I guess I would say three, but they're in two areas that we are asking. And because we didn't meet until 8 this morning, it took me about an hour to put this together. And so I sent this morning at around 9:30 to Anthea and Senator Perchlik, and have not had an opportunity to get any feedback from them on whether or not they have had a chance to look at it and their thoughts on it.
Well, one of the things I want to make it perfectly clear, because we're doing so much, we're not going to rush into this unless we've got some consensus among the committee and we understand exactly what's happening. So it is a very important issue. And if someone needs more time, we're going to offer that time. We're not going to jump into something. So I'm glad you're responding, but like I said, if you need more time, feel free to ask. But at this time, who would like to comment on this language? Senator Perchlik?
I'm happy to go over it if you'd like me to go over what our concerns were about the
Sure.
draft.
You want to do
Or
that?
if Senator Perchlik's okay with it, then I don't need to do that. But if,
Well, no, I want to make sure that everybody's comfortable with it.
yeah,
Well, we could have Claire go through her draft this one, but we could also, I'm pretty sure Anthea created a new draft with these changes. That
Okay.
So if we want to see it as draft bill language, I don't know if that's easier than the way Claire has it, but
Claire, what would you like?
If this is incorporated into a draft as I proposed, then I'm okay with looking at that draft.
Why don't we look at the draft then, okay?
Okay.
Okay,
Haven't seen it, so.
all right. Well, that's all
It
right.
looks the same. The editors moved, or I deleted things before inserting things and they
Oh,
changed that around, but it'll look very similar. One sec, let me just make sure I'm pulling up the right thing. And Liz, I will send this to you as well.
I think Liz posted it, you know?
Liz had only posted Claire's
Okay.
response and the draft that I just walked through. This is going to be labeled as draft 1.3A.
You like to test your lobbyists live on Zoom, huh? Throw a draft at me and see what I have to say about it.
But you could do your draft. I mean, if that's more comfortable for you. I just didn't know if that was better to see it as a build language.
We're listening to you, Claire.
Claire, how about I put this up and then if it's weirding you out and you want your version back up, Liz can put that up.
Perfect.
Share screen. Okay, can you guys see a 6-page draft that at the top says 1.3A and has a time of 9:45 a.m.?
Yep.
Okay, great. Claire, there you go. There's your first proposal.
Okay, so our first proposal is in section 1, as you can see, subdivision 13. What this would do is when we were looking at the language again late last night and this morning, we just wanted to ensure that a franchised OEM, which is your traditional franchised manufacturer, is prohibited from operating any dealership in Vermont. And we just felt like that language was a little bit loose the way that it was presented. So we have added just a sentence that says, in the definition of new motor vehicle dealer, and it's talking about, who holds or held at the time a cause of action, a valid sales or service agreement, franchise, or contract granted by a manufacturer or distributor for the retail sale of said manufacturer or distributor's new motor vehicles, and is not affiliated by ownership or control with the franchisor. So what that's saying is that the dealer is not affiliated by ownership or control with a OEM manufacturer. A franchisor is somebody who has a franchise with a new motor vehicle dealer in the state of Vermont. And so that's that proposal.
And I'll just chime in there. This would not be affecting the definition that's being added later of the non-franchised ZEV manufacturer. So we're dealing with two different definitions.
Senator Kitchell, I think you were muted. You were speaking.
Yeah.
Okay.
Could you restate, in other words, this is being added. Is this a belts and suspender? I'm just trying to understand what this does or why this is important. And maybe Anthea, you answered it and I didn't really hear what you said.
I didn't answer it. I think probably, and I would need to go back and look at the definitions that exist for franchise and franchisee and franchisor in chapter 108, that this probably is a belts and suspenders approach given the current sort of business model where you have manufacturers, franchisors that are entering into franchise agreements with dealers, franchisees, but that franchisor, the manufacturer, does not own or is affiliated with the franchisee, the dealer, except for the agreement that they're entering into, which is not one of ownership or control.
All right. And Claire, you would, do you concur with that?
Yes, this is our
Okay.
proposal, and we would very much appreciate your support.
No,
for.
I mean, in other words, what Anthea just told us relative to what this language does, that it's a kind of a restatement, or are you introducing something new here? That's what I'm trying to understand.
I see.
What you're trying to achieve here.
Yep.
And is it a clarification of what currently exists, or sort of a strengthening of what exists, or is it something totally new?
I would put it in the category of strengthening what already exists. I guess what we realized was there wasn't, while everyone assumes that the OEM isn't going to, and by OEM I mean sort of a legacy manufacturer who, you know, a franchisor is not going to own the franchisee. It didn't really specifically say it, and so we would just like to add that to the statute to make it crystal clear, and that was our proposal.
Thank you.
Okay. Next.
Okay, so this is in the definition of non-franchise zero-emission vehicle manufacturers, and one of the provisions, one of the requirements for them is that they had not sold or transferred, and what was in here before that's removed, I believe, in the other draft. Well, I'll start with our draft. Our original draft that we gave you yesterday, or that you considered yesterday, had the term that this provision stated that they were not affiliated. Okay, so that was this, and I'm looking for the draft, but of course I can't find it right now. Okay, here it is. Sorry. That the non-franchise zero-emission motor vehicle was a manufacturer that is not affiliated directly or indirectly with a franchisor or a subsidiary or other entity controlled by the franchisor. So what that's saying basically is that, say, a Tesla is not, doesn't have a direct affiliation with a Ford, for example. I'll just use that as an example. So our language said not affiliated, no affiliation. And then the draft that Anthea presented earlier, the draft 1.3, had in it that it couldn't be a controlling interest. And we had some concerns about that, about changing this particular provision. And so we proposed this morning that it be a combined direct or indirect ownership interest of greater than 10%. And I appreciate that is in the draft, and we do support that. And I'm just looking to see if anything else was changed. We had also proposed in here that what this says is that, say, the Tesla, I'll just use it as an example, but the direct-to-consumer zero-emission manufacturer that fits this provision would not sell a part of their business to a franchisor, to a legacy OEM of not more than 10%. And we had a second provision in here, and I guess I'm just curious, Anthea, I don't see it in here. The second side of the sentence was that, or that Tesla or, one of these entities would not acquire a direct or indirect interest of greater than 10% of an OEM. So that, I guess you guys left one part of it out, but this maybe I'm not reading it right, or maybe there's another section of the bill that I don't see, because I'm just looking at this for the first time. And did you see that our draft kind of had two pieces to it, what I call the two-way street? And I didn't know if that was left out or not added in intentionally, or if that's just because I sent you the draft at 9:30.
So Claire, I'm looking back at your proposals, and you had in new motor vehicle dealer in 408518D, you had made a
It's the end of that.
Oh, I
sentence.
see, has not acquired. 1 second. Yeah,
That part.
I'm sorry. I was moving very quickly. I was in another committee at the same time. So yes, I'm going to switch over and put Claire's language up so you can see that. I apologize. That should have been incorporated. This was intended to reflect Veda's proposal. So you should now see something that I am highlighting in section 2.
Yep. Yep. That would be it right there. So it's very similar to what Anthea put in the draft, but we had one more side to it. So this was a change that, you know, was made in the draft that was sent to us last night. And so this is the language we would propose, which basically says that one of these new non-franchise zero emission vehicle manufacturers cannot, if you cannot sell or transfer a combined direct or indirect ownership interest of greater than 10% to a franchisor, so to a legacy OEM. And then there's a second piece of it which also says, or you cannot have acquired. So this non-franchise zero emission vehicle manufacturer cannot have acquired a combined direct or indirect ownership of greater than 10% in a franchisor. And so what we're talking about here is in the first part of the sentence, it's that one of these companies couldn't own more than or couldn't have sold more than 10% of itself to an OEM. And in the second part of it, it's that one of these companies cannot have acquired greater than 10% in an OEM.
I need help on this. They could do it, but it would mean that they wouldn't meet our definition. I mean, we can't control the sale or ownership interest in, as I wouldn't think, as it would relate to these businesses that they aren't even domiciled in Vermont, these manufacturers. So this is our definition that we're putting in place. But when you say it wouldn't allow it, I just want to be clear, it would allow it to occur. It's just how we would be defining it in Vermont. So when you're talking about a prohibition, anybody who's listening, I don't think we could say we're prohibiting those kinds of business transactions for those manufacturers, regardless of whether they're a franchise, they work through a franchise model, the legacy, or a new one. We don't have any authority over that. It's just how we're defining the entity for the purposes of business in Vermont.
Yes, absolutely. I apologize if I used the wrong terminology there. You're absolutely right. It is a requirement of one of them that they don't do either one of these things.
The intent is not to circumvent that franchise system by acquiring. I think I understand what you're trying to do, but I was getting a little. I knew what you were trying to say, but I wanted to be clear that we weren't in any way attempting to interfere with these business deals that are existing between corporations that are not even occurring, and I would suspect in Vermont.
Yes, Senator Perksley.
Yeah, thank you. I have trouble with this part of the proposal. I don't have trouble with the first part, but this part I'm concerned, especially about the second part, since these could be public companies. You don't know who's buying your stock on the open market. Like you would have no way of knowing. So you could just wake up one morning and say, "Whoops, somebody bought over 10%. I got to shut down my Vermont dealership." And so I don't see how that could really work with a publicly traded company. And so that's the second part of that. In the first part, I like controlling interest. I hear the dealers saying they're concerned about that. 10% seems like a small number. to prohibit it. So, you know, a lot of these are new startup companies, and if they can get the money to get started, and somebody just happens to get over 10%, and what day do you rate that? The day that they apply for for their Vermont dealership license, or, it just seems like a tough thing to police as well. But I'm okay with putting a percentage in there. I just think 10% is too low. Because it's just like, I don't think that really has much impact if Ford, like with the Rivian example, if Ford invests 11% in Rivian, that just prevents Vermonters from buying those cars here. So I don't know if there's a compromise with a larger percentage, if you want to keep a percentage and not controlling interest. So I guess controlling interest is 51%, and I think the second part is unworkable.
Comments, questions?
I mean, I'm happy to, that was the first opportunity that I had to talk to Senator Perchlik about this.
Okay.
And
Let me tell you what I think we should do. We'll continue the discussion on this, and then we'll, because everybody had short notice, we will continue. We'll probably spend the rest of the day today. You can do some negotiating back and forth and bring it up again tomorrow morning. So I want you to continue the discussion this morning, but also maybe there's no definite decision made today because it was known late last night. And I want to make sure everybody's had their opportunity to discuss their issues. Does that sound all right?
yes,
Okay. Go ahead. Anybody want to continue our discussion of other issues, other parts, or?
did we go over the line make piece of it or not? No.
Not yet. Okay, go right ahead. Then we'll.
And I think this is related to the first point, which we discussed, but we didn't actually look at it. So this goes back to that first issue, which is that we just really want to amend the language to say that a franchised OEM is prohibited from operating any dealership. And in order to do that, we needed to make that first change that we all discussed and this change. So it would in current law, it says to compete with it's a violation of the chapter for a manufacturer to compete with a new motor vehicle dealer, and it says in the same line make, and we would propose to take out the in the same line make. And this goes in tandem with the first the first amendment that we talked about that said it is not affiliated by ownership or control. This is a separate issue from this just relates only to franchise dealers and franchised manufacturers and not the non-franchised zero emission vehicle manufacturer.
Questions?
And can you just maybe the dealers or you, Claire, can just remind us the definition of same line make? I think I agree with this, but I'm not 100% sure I know what that term means in business.
Well, line make is actually a defined term of art in the existing franchise law, and I could read it if that would be helpful. I have it right here.
Yeah.
Sure. It says line make means motor vehicles that are offered for sale, lease, or distribution under a common name, trademark, service mark, or brand name of the franchisor or manufacturer of the motor vehicle.
So it opens up. So instead of limiting to that, you're just saying no competition on any of these cars, not just that branded car.
Correct.
I'm okay with that.
Senator Ingalls, you understand all this?
I do. Yeah, I do. Yeah, you have to. Yeah, I do.
Okay.
I think it's I sympathize with the dealers. I sympathize with anybody that's in a franchise agreement, and I understand why you have to be very, very precise. Without going into a lot of detail, I own 2 franchises now, and I just went through a situation with the franchise that I'm dealing with that I wasn't very happy with. And I had to go back and look at a lot of different languages, and I just signed a new franchise agreement. So I made a lot of these changes myself as well. So I understand where the dealers are coming from. I'm in favor of this S47 bill. I'm also in favor of working with the dealers to get it right and offer them some protections. I understand where it's going.
Well, that's why I think we're making progress, but I want to make sure I don't rush into something that we want to make sure that everybody, gets heard, and make sure the dealers, I know they won't get everything, but at least we'll make a commitment to do the best we can and continue on in the future. So I think that's important, because we all respect and acknowledge our dealers of what they do for the state of Vermont. But so wherever they take a little
My
time,
only comment was to say this gets into such arcane areas
Yeah,
that
that's right. That's right. No doubt
I'm
about
really,
that. Wow.
I am really trying and
Gonna be a
struggling
lawyer.
to understand the nuances, and for
Yeah, I
those
agree with you.
who deal with this. And that's why I was asking, because I know Senator Ingalls you talked about, you came down and testified a number of years ago relative to the last time changes were made. So it's like, there's a certain comfort in knowing that there's somebody on the committee
Right.
with that detailed knowledge.
Yeah, it's very involved. Yeah. Any other parts that we want to go over this morning?
Was that all your suggestions, Claire, or did you guys have others?
No, those were the 3 suggestions that we made to you this morning are what we would, that's it. I think we went over all of them.
So yes, Senator Perklick.
And this is a question for Anthea. In that same section we just talked about with the same line make on line 19, that one part that's struck out in the relevant market area. I think I asked you about this. Maybe you already answered me in email. I can't remember. Why are we striking that out?
You are striking it out because it was one of the things that was raised in Veda's current proposal. And I am not sure if relevant market area, relevant market area is defined in statute. And I will put this up on the screen so everyone can see it. I have a very hard time processing it when definitions are read to me without seeing it also. So relevant market area means the area within a radius of 25 miles around an existing dealer or the area of responsibility defined in the franchise, whichever is greater, except that where a manufacturer is seeking to establish an additional new motor vehicle dealer, and there are 1 or more existing new motor vehicle dealers of the same line make within a 10-mile radius of the proposed dealer site, the relevant market area shall in all instances be the area within a radius of 10 miles around an existing dealer.
Take that to court. 2 lawyers and have fun with that one.
We're going to give Senator Kitchell a migraine. So my question on that is not about that definition. I don't want to get into that, but maybe this is a question for the dealers or Claire about. So if we take that out, is there no geographic? I just wonder, does that make, what if they're selling cars in California? Could you say that they're competing? Like, it seems like you'd want to say in the state or something. Like, am I missing something? Why, if we just take out that there's no geographic boundaries? Or does my question make sense?
I'm just trying to figure out exactly where.
But you can take that question and think about it.
Okay.
Yeah, we can talk about it later. But
Yeah, we can talk about it later.
I'm sorry.
No. I don't want anybody jumping into detail.
Okay, it's 8A. Okay, it's section 8A. That's helpful to just know what section we're talking
Right,
about.
that's right.
Because I didn't know what. Well, yeah, maybe I'll take that one.
Yeah, this is for
advisement.
discussion purposes the rest of the day, and then tomorrow we should probably have some agreements. We hope. I think the committee's on board to do the right thing, and we want to make sure we look at all possibilities. You have a chance to digest it, as long as, working with the folks. I would like to ask at this point whether Bob Cody or Mitchell J have anything to say at this point before we reconvene tomorrow.
Well, I'd just like to say thank you for working with us and doing the best we can do to come to some sort of agreements. That's great. We
Good.
appreciate it.
Mitchell, anything?
Yeah, no, I appreciate it. And I was just going to mention, I think, like you say, Claire can get back to you on that relevant market area.
Yeah,
I think the concern, and I remember Senator Persick, we talked about it last year, was a company like Volvo that's creating Polestar as a separate line make. And, you know, in these franchise agreements, they can describe relevant market area. They adjust mine every few years. I have no say. They just say, this is your new relevant market area. So that the bill, the way it's worded, you could have Volvo turn around and take, say, the Al Martin Volvo and say, well, your new market area is Burlington, South Burlington, and Winooski. But by the way, we're opening up a store 11 miles away now for Polestar. So that's, and I'm sure Claire can look and work with Athena and make sure it is in Vermont. But that was always my understanding is this is the Vermont franchise law, so that it would be a violation of the manufacturer to open another store in the relevant market area, which we're taking that out, just saying in Vermont, because it, and I know it, like Senator Kitchell said, it gets in the weeds, but boy, they come up with lawyers that try to figure out the slightest little nuance of what the word "it" means or something and everything. So,
Yeah.
Yep.
Mr. Chairman, with respect, this is Wayne Whitewood, the Alliance for Automotive Innovation. We had asked for time today on this.
Okay. Yep. Okay, go right ahead.
Great, I appreciate it. Sorry to jump in. I just didn't want you to.
I know.
bang the gavel.
No, we're still open. Yep.
It's just a couple comments. I first have to start with complimenting Anthea and how lucky you guys that she can keep up with you.
Tell you, she is fantastic, and that's why we hope she sticks with us.
Second, I have to kind of echo where Senator Kitchell and Senator Perchlik went. You know, I feel like we've sort of lost the thread on a bill that we were talking about, trying to expand the EV access for consumers in Vermont. And now we're talking about mergers and acquisitions of billion-dollar companies, and whether those acquisitions that happen somewhere else will mean they can sell in Vermont sometime later. Again, sorry, for the record, Wayne Weichel, the Alliance for Automotive Innovation. We represent the automakers that manufacture nearly 99% of all new vehicles sold each year, as well as major tier 1 suppliers, as well as other automotive technology companies. It's important to remember that, you know, each state has a set of franchise laws. They are some of the most complex laws on the books that each of you are now realizing with some of those definitions that Anthea read. Every one of those things have been hard won through negotiations back and forth to find a compromise. And what VADA has done is come to you with some things that they've pulled from one state or another, and they haven't taken into account what was given up or negotiated to get those concepts. You have to view these things, you know, in their entirety. And, you know, as the vice chairman, I think rightfully predicted yesterday, you know, if this bill goes down this track of franchise, it would be our opinion that it should go to the committee that has rightful jurisdiction over franchise to review these items. You know, it's just watching your reactions when some of these definitions were read to you, like that is how complex all of these things are. You know, obviously we'll need a minute to review some of the changes that came in yesterday, but just talking about some of the ones that I know are still in there. This idea from Section 7 yesterday that the dealers wanted to make sure that there's no competition between auto manufacturers and dealers. And they specifically referenced selling and leasing. But what the language does, and even the new language today does, it includes other things. It includes parts. No other state in the country prohibits the sale of parts within their state that have to only go through the dealer franchise system. I mean, this would mean you couldn't dealers would be the only source of OE parts in the state. It means you couldn't go down to a third party to buy them. It doesn't say who you're selling to, it just says selling. So you couldn't go to a local store, you couldn't go to online, you couldn't, Mr. Chairman, you couldn't go to the manufacturer and buy a crate engine directly from the manufacturer, is sort of how that happens now. No state's adopted something like this. They also, as noted, prohibit manufacturers from having a subscription program. A subscription program, I'm guessing most of you haven't heard of these, are new products that some companies, not just automakers, but others as well, are exploring, seeing if there is consumer acceptance of. And what these are effectively rental membership programs that allow you to alter your vehicle usage throughout the year. You want a convertible in the summer? Great. When it gets to the winter, you want to swap out for a 4x4, you can do that. If you need a pickup truck to move, you can swap out for that. It's a different sort of model. It's unclear if it's going to work. It's unclear if consumers are going to accept it, but it's something that's being considered. No state has prohibited subscription programs, but that's what VADA is asking for. In their summary yesterday, they asserted that Massachusetts and New Hampshire had legislated on this already. And these subscription programs are brand new, 2 or 3 years old. In the citation they gave you for Massachusetts is they use the word subscription once in a definition, but it's a law that was updated last in 2002. Clearly not talking about this new membership model of vehicle use. Same thing for New Hampshire. I haven't had a chance to dig in, but I'm guessing it's probably the same sort of thing. No state's taken action to prohibit a subscription model. And again, that's what was in that section 7. And even just jumping back to, to sort of show how this hasn't really been well thought out yet, jumping back to the most basic premise of that section, which was that they shouldn't compete with buying, with selling or leasing. Well, a dealer doesn't lease a vehicle. A dealer, when a consumer wants a lease, sells a vehicle to a third-party financial arm that then leases that vehicle back to the consumer for payments over a certain period of time. If this says that an auto manufacturer can't be involved in leasing, does that mean an automaker's financial arm that offers those leases to consumers now can't offer a lease in the state because that would be competing with a dealer the way this is drafted? I don't know. I mean, that's how I read it. That just shows what's in here. These are not innocuous things that they're just adding in here. Sure, they sound understandable when someone gives you a brief explanation summarizing their request. And I should note, we do our best to not come to policymakers asking them to choose winners and losers between businesses. We know that is not an enviable position for a policymaker to be in. So we try to work these things out ahead of time. I provided Liz with a copy of a letter that we sent to VADA in December, which covered a couple different things, but specifically said, if you have issues with the franchise system that you would like to talk about, we're here. We send this letter every year. We never heard from VADA, didn't hear anything from them until this came up. Just wrapping up here. We still oppose, with all due respect, Mr. Vice Chairman, we still oppose your underlying bill that would allow some manufacturers to play by a different set of rules than their competitors. But what we really object to is taking that bill that gives special treatment to some manufacturers and loading it up with additional things to make those that are playing by the law make their jobs harder to do business in this state. I mean, this is a pretty obvious example of why Tesla and Rivian don't want to use the franchise system. There are existing contracts to govern this relationship, and dealer associations come in and ask to change the law that govern those existing contracts, that supersede existing contracts. That's why they don't want to use the franchise system.
Where do you propose the dealers go to get any changes in legislation if it isn't the legislature?
Sure, I fully understand. That was my next paragraph.
When you said that didn't belong in this committee in the first place, this is what this committee, this was bill was assigned to. It may go to other committees. We were given the committee, the bill to our committee because that's where it was designated to go. Now it may go to other committees. So, if the dealers have a complaint, where do they go other than legislature?
I fully understand, and that's
okay. As long as we understand each other. Thank you.
No, I fully understand, Mr. Chairman. That was my next paragraph for what I was getting. We would suggest that you reject these amendments so that they can be either studied. If you want to put them in a study, that's fine. But this was sent to you as the appropriate place for an EV bill. But now if you add in franchise bills, yes, it might have to go somewhere else. But we would recommend putting these all in a study, talking about them, and have the bill filed as a normally filed bill ahead of next year, instead of trying to wedge these into a bill that is on another topic. I'll close with that. I've gone longer than I had originally intended.
Questions? Okay, any questions, comments at this time? Yes, Bob.
Thank you, Mr. Chairman. I'd like to just say one thing. It's, changing the franchise laws, making some changes to it. I think Senator Ingalls will agree with me that being a franchisor, sometimes they change the game for us quite often. As Mitchell J said, they changed the area of primary responsibility at their whim. Not really a fair thing sometimes, but we put up with it because obviously they're stronger and more powerful than we are. We don't have the ability to hire lawyers and challenge them. So I can tell you I've been doing this since 1983. My family's been here since 56 with General Motors. And I can tell you that they have changed so many things and promised so many things that never, ever happened. And so we do need some protections. And, so sometimes we may have to come to the legislature and make some changes to the franchise laws. Again, they change the rules on us all the time.
Any other questions at this point or comments? If not, we're going to digest what we did today and we will take it up tomorrow at that. Liz will schedule a time. I think we got some time in between between 10 and 12. So we'll let her schedule that. So with that, it is 12 o'clock and we'll be done for the morning. Thank you very much.
Thank you, everyone.
Thank you,
Appreciate it.
everybody.
Thank you.